Hey everybody, Todd Vandermine back for another edition of Freedom Steel. So it's 7:30 in the morning, and as I'm sitting here waiting for the Illinois Supreme Court, I thought I'd kind of give you some insights to what happened yesterday with the denial of cert of the Bian case and the relisting of the Illinois cases. So a couple of things here. Mark Smith, I think, did a very good analysis of some of the things he thinks the court may or may not be doing. Some of the other YouTubers out there who offer a lot of commentary about 2A issues are decent guys and mean well. The problem is they're not from Illinois. They're not involved in these cases directly. As such, they don't know the nuances. They're not working with the lawyers. They're getting everything second or third hand. And they mean well for trying to get the information out to you, but they're not always spot on. So let's start with Bianchi. Yesterday, and when the court published its orders, they sat there and said that in the Bianchi case, cert before judgment was denied. Now, a lot of guys have criticized and commented that I use a lot of terms that people don't understand. So this may be part educational and may take a little longer as I walk. So cert is short or slang for certiorari, which it means that the court is taking a writ to correct a order from a lower court. So whenever you hear us say cert, it's short for certiorari, which is the term of when the Supreme Court is going to take a case and therefore hear it and consider whether the lower court was correct or not. I've got a tickle in my throat this morning, so I'll keep letting it down as I edit this down. The Bianchi case was sitting at the court in 2022, 2 years ago now, when the New York State Rifle and Pistol case came out. It was then GVR'd. Here's another one of those terms. GVR is short for granted, vacated, and remanded. So the court grants cert, accepts the case, but instead of doing briefings and everything else, they automatically vacate the lower court ruling and then remand it, there's the R, back down to the lower court with instructions. And in this case, they did the Cali magazine ban and New Jersey mag ban. They did the Maryland semi-auto ban, Bianchi, and they said, try again, see New York. In which case, everybody thought that because of that, Bianchi would have a better chance since all the shenanigans in the Fourth Circuit, the court may be fed up with that. That didn't happen. So what also happened is there are a number of Illinois cases pending at the United States Supreme Court asking for them to grant review and take up the semi-auto and magazine ban and repair bans that are here in the state. And those cases were posted and relisted for this Thursday's conference. Now, it's not uncommon for cases of a particularly controversial nature to be relisted multiple times. And there are several schools of thought. There's one school of thought that we're going to be denied, and that's because we're still in an interlocutory phase. Interlocutory, another one of those terms we use. That means that we're still arguing about procedures and things like that. We won in the Southern Illinois cases. We won a injunction. It went up to the Seventh Circuit Court of Appeals. The guys up north, Herrera and Beavis, had lost theirs, and the court decided to stay the injunction issued against the state in the Southern Illinois cases. So up till this point, everything has been an argument about whether or not it was proper to stay the injunction or grant the injunction or whatever. And it's in a almost administrative posture to where we're dealing with peripheral issues. We're not dealing with the merits itself of the case. Although one of the items of winning an injunction is the propriety that you are likely to win on the merits of the case, but the Seventh Circuit saw it differently. The Seventh Circuit sought to revive and put on steroids the original Maryland ruling, not from Bianchi, but from the case prior to that, saying that AR-15s are military-style firearms akin to machine guns, and therefore they can be banned. So the court, they're going to relist and reconsider the Illinois cases. But let's walk through the Illinois cases. There's a case called Langley, filed in Southern Illinois. It's an independent case filed by an attorney, Thomas Magg, who's had numerous cases in front of state and federal courts about the 2A issue. You have Barnett, which is the NSSF case. You have FFL Illinois, which is its own separate case. The biggest difference is the other cases. There are 4 cases in Southern Illinois. 3 of the cases are gun and magazine ban cases. FFL deals with guns, repair parts, and registration. They're the only guys that are tackling right to repair, the only guys tackling registration, and went back to court to argue about the registration. You have the Harrell case, which is the SAF FPC case that's being handled down there. Now, out of the north, you have the Herrera, which was a challenge to the Chicago, Cook County, and state ban. I thought that was a mistake. You have the Beavis case, which came out of Naperville. It is being funded by the National Association for Gun Rights. Now, GOA had filed a brief, and some of the YouTube commentators have talked about the GOA case. The GOA case is the FFL case. GOA came on board with the FFL case when it was filed. So your 3 main entities are FFL Illinois, Gun Save Life, and Illinois Grassroots Group, and GOA. All right. GOA decided they wanted to file their own cert petition in our case with the Supreme Court. GOA does not have a standalone case. Eric Pratt and all those guys are doing yeoman's work, but they joined the FFL case here in Illinois, kind of as economy of trying to pool resources. But everybody was so hot to get the first case in front of the Supreme Court, and with everything going on, NSSF partnered with NRA. You had SAF partner with FPC and ISRA. The FFL guys partnered with GSL and GOA. And part of it is that in the FFL case, we wanted to have a different look. We felt that and I'm involved in that case, and we felt that magazines could be its own case. It would take all the briefing up if you really wanted to. Though you've seen this go on in Washington, you've seen this go on in other places. Now, there's another case out there that very few people are talking about, and that's a case called Veramontes. Veramontes is another SAF, FPC, ISRA case that was started off several years ago as an attack on the Cook County semi-auto ban. It began in late August of 2021, and this case has been hanging out there. It was filed in the Northern District. They drew a bad judge, and it's just been kind of languishing out there. Well, except on March 1st of this year, Veramontes got a final decision on the merits. They got through all the BS, admin stuff, discovery, all of that kind of stuff. And they got a final judgment. And on 3/15, they sat there and filed a notice of appeal to the Seventh Circuit. And there's some haggling going on around what issues are actually before the Court of Appeals and all that. So let's, as you get your bingo card out, let's talk about a couple of different things. One, the relist. So 3 of the 4 cases in Southern Illinois went up. You have the other 2 cases from Northern Illinois. So you have 5 cases actually pending in front of the Supreme Court. Now, they could. Why did they relist? Well, there's speculation. Could it be that there is going to be a dissent in taking the cases, and that Thomas Alito or somebody is writing a dissent? Thomas has been very vocal in his dissents when they refuse to grant cert, and has been spelling things out. He did so in Friedman back in 2015. A lot of these petitions for cert sat there and had a lot of bare knuckles and sharp elbows talking about how bad the lower courts were treating this issue post New York. They could just, on the relist, they could potentially be waiting for Rahimi or Cargill. And if there is language in either of those 2 cases, even though Cargill is largely an APA case, the American Procedures Act, or the Administrative Procedures Act, and that's a law that deals with how agencies issue regulations, that, the FFL guys, the Second Amendment Law Center, the Second Amendment Defense and Education Coalition, filed an amici brief saying, hey, you got to talk about AR-15s and how common use they are and things like that, trying to get the issue in front of the court in a different way. So with that, we've got that out there. And could it be that they are relisting our cases? Now, one would thought if they were going to do that, they would keep Bianchi alive out there. But Bianchi had oral arguments in front of the en banc full Court of Appeals. And so with that, it's in a different posture. So did they just dispose of that, knowing that the Court of Appeals is going to do what the Court of Appeals is going to do, and they sat there and have now, they're going to take an opportunity to say something about our cases. Hope against hopes, they could issue a per curiam opinion. It's an opinion of the court that's largely unsigned. Catano, I think, was something similar to that. We could get a opinion from the court saying you're getting this all wrong, fly right. That would be just some guidance from them like that would just be remarkable. I doubt that's going to happen, but you kind of hold out hope. Or they could issue Rahimi and then GVR the case and say, hey, we meant what we said in New York. Here's some further clarification, either through Cargill, AR-15s are in common use, Rahimi, this is how you do text traditionary history. Don't know. So you've got all that. They could deny us, and that's possible. And what else is going on? So in the Southern District, Judge McGlynn is trying to move this case as quickly as possible. The good news is that by the time we start looking at a trial, we will have the term of this court concluded. We will have Rahimi, we will have Cargill, and hopefully we will get some new guidance from the court surrounding our issues, and it'll be beneficial to us. I think Rahimi's going to lose himself, but I think there are going to be some positives that come out of the Rahimi case for our side. And then you've got Veramontes. Is Veramontes going to jump the other cases? They've got a final decision. We're still set to go to trial in Southern Illinois. Are we going to get a final decision, or they have a final decision, and is that going to then go up to the Seventh Circuit? Is that going to leapfrog everything else? Would the Seventh Circuit then take that case, knowing all these others are right behind it, and turn around and issue another opinion, just doubling down on the stupid they did in our previous opinion, and tee all that up? Don't know. These are all the machinations. And one of the things that is trying to get done in Southern Illinois is we know that the state does not like the pace that the case is moving at. They are trying to drag their feet. They are trying to slow things down. And they have intimated in conferences with the judge that if he pushes too fast, they are going to make an appealable claim that they did not have the ability to vet everything out. They didn't have proper time for discovery. They didn't have proper time to look at experts, that they were rushed into this, even though this thing has been litigated for over a decade in lower courts around the country. So, uh, you know, we've had federal courts here, the Seventh Circuit, look at Wilson. We've had the courts out in California. We've had all kinds of other stuff. So that's some of the inside baseball and a different look at what's taking place here in the Illinois cases. We have several outcomes, and since next Monday is Memorial Day, we won't get orders until Tuesday. So, with that, guys, I hope this is informative. Didn't want to run too long here. Wanted to get some stuff out there for you. So, please like, subscribe, copy and paste the link, and share it with all your friends on social media. You will have more information about Illinois cases coming out of us than you will almost anywhere else. I think Mark Smith does a really good job of trying to get stuff done. I think the other guys are always throwing content out there. They're just not as close to the situation as we are here at home. So, as always, thank you very much. Frag out.